So the Information Regulator has set up an enforcement committee, finally, to help deal with complaints over the unlawful handling of personal information. This committee is made up of 14 independent experts, we're told, and is required to make findings on matters referred to it by the regulator. It will also make recommendations for criminal action against public and private entities that fail to comply with the Protection of Personal Information Act. Let's get you more on this now. Speak to the Information Regulator's Mukelani Dimba, who joins us via our video link this morning. And it's great to have you on the program, sir. Thanks very much indeed for making time. You might have heard what I threw in there in that introduction around this committee finally being constituted, and that's because it's a year after amendments were made to the POPIA. Why did it take so long?
No, it didn't take long at all. You must remember that we have a dual mandate in terms of our work that we do. We are supposed to do promotional work, which is letting people know about the POPIA legislation and POPIA, and also to assist the implementers in complying with the legislation. So a lot of our work over the last year or so has been around promotional work. But at this point, the regulator is shifting gear. We're now focusing on the enforcement part of our mandate, so as to strike the necessary balance between promotional work and enforcement work.
All right, so we're going at a reasonable pace, is the sense I'm getting from you. Tell us about whether or not this committee's work would be retrospective, because whilst there's a need, of course, to go through this step by step, there may very well be violations to the POPIA and the POPIA.
No, absolutely. I must say that it won't be retrospective in a sense that the committee won't be able to look at matters that were reported before the 1st of July 2021 because the legislation came into force. Our enforcement powers came into effect as from the 1st of July 2021. But certainly there have been matters that have been reported to us, that have been investigated, and those are ready to be attended to by the Enforcement Committee.
Sure, and we'll speak about that process in just a moment. Let's speak about who makes up this committee. 14 independent experts from information security, education, we're told, finance, accounting, auditing. What went into deciding which of these individuals are suitable enough for the committee?
You see, POPIA by its nature makes itself applicable to a wide range of fields.
Yeah.
There are instances of conflicts between the data subjects and the responsible parties that happen everywhere in all sectors of our economy and society. Therefore, when we constituted the Enforcement Committee, we wanted to make sure that we have the benefit of individuals with expertise and skills in a wide array of fields, as you have rightfully indicated. We have people from the finance sector, people from the educational sector, people from information security sector, etc. So basically, we feel that we've covered a lot of ground by constituting this committee in the way that we have, and the matters that come to the regulator from each of those sectors, each of those fields, will be attended to with a high level of skill and expertise.
Yeah. When we speak about the dissemination of information, there's often two conflicting interests. I mean, on the one hand, you do want to protect people's personal information for their own interests, but on the other, there's matters of freedom of expression and making sure that there is information for the public interest, if you know what I mean. I imagine these are some of the things that, this committee will have to negotiate when making some recommendations.
Absolutely. I mean, we need to remember that POPIA is not about shutting down the free flow of information in society. That is not what POPIA is about. The POPIA is about balancing those conflicting interests and those conflicting rights. So the task of this Enforcement Committee is to really assist the regulator in striking that necessary balance between protection of information lawfully and the free flow of information, which is desirable and a public good in any case. So that pretty much is going to be the guiding philosophy behind the work of this Enforcement Committee.
Yeah. Their recommendations, according to my understanding, could also include criminal action against people who I imagine are found guilty. And the only recourse, we're told, is the courts. What informed that decision? And perhaps you can explain to us the process leading up to that.
So what would happen, or as described in POPIA, is that where we receive a complaint from a member of the public, the law calls members of the public data subjects, When we receive a complaint, we do what is called a pre-investigation, just to try and establish the facts behind the complaint. And once we have evidence that there is indeed concern in how information that relates to this individual was managed by the responsible party, we do a full-on investigation. Sometimes these complaints do get resolved at the level of the investigators, either during pre-investigation or during investigation. But some of these complaints can be complex, which requires that the investigators should put together a report, an investigative report, and that is the report that then gets forwarded to the enforcement committee. The enforcement committee can either adopt the report or reject the report, or they can actually run their own investigation. It's allowed in terms of their rules of procedure. Once they've done their work as enforcement committee, they then have to make certain recommendations to the members of the regulator. And those recommendations will then become what is called an enforcement notice. The enforcement notice has the same effect as a court order. Remember that the Information Regulator has order powers. It can order certain action to be taken by a responsible party. And of course, the responsible parties are well within their rights to seek redress or a review of our decisions with the high courts. But we are empowered by POPIA to, in that enforcement notice, to issue fines or to where there's egregious violation of people's rights to protection of information, we can actually order that criminal action or civil action be taken against the responsible parties, which can lead to either fines or imprisonment. So basically that's how the system would work.
Sure. You know, part of the criticism that the courts are facing, especially the Constitutional Court, is around how long they take for matters to reach finality. I wonder whether or not, it's worth considering some kind of timeline for this committee, at least until the point where they can finally give that enforcement notice to members of the regulator, in a context where we know these things could take a long time.
It could take a long time, but you must also remember why the Information Regulator was set up in the first place. The regulator was set up because there was a realization that the normal court processes can take long, can be very expensive. And so Parliament decided that there should be this sort of alternative dispute resolution mechanism, which is the Information Regulator. And therefore, we are required to work differently than the courts. Otherwise, there would be no merit in the work that we do. So we certainly would be operating on the basis of a swift, rapid decision-making. Of course, we want to ensure that the investigations are thorough, and they can stand any kind of challenge. So the investigation process needs to be quite detailed. It needs to be quite thorough. So you'll find that some of the cases may take about 6 months to investigate. Some of them may take about 12 months to get to a point where a report is forwarded to the enforcement committee. But when it gets to the enforcement committee, this is when we would expect rapid decision making, because otherwise there would be no need for somebody to come to the regulator if we will take as long time as what people would ordinarily experience when they rely on the normal court system. Yeah,
but you're not going to pin yourself to a specific timeline, are you? Fair enough.
No. The enforcement committee will have to, as their first order of business, they will have to have a look at the terms of reference and settle their rules of procedure.
Sure.
So all of those timeframes are going to be articulated in those two documents.
I appreciate that.
We did not want to impose these timelines before the enforcement committee was in place. Now that they are in place, we are then going to have a discussion around the specifics and articulate what the process flow is going to look like.
Fair enough. All of this work, of course, almost falls to nothing if ordinary citizens aren't aware when their rights are being infringed and therefore don't approach the information regulator. Part of what you've mentioned this morning is that the work that you've had to do in the lead up to the establishment of this committee is around awareness. Are you satisfied with how that's fared? Put plainly, do you think enough people in this country know when their rights around this are violated and know where to go?
No, most certainly we can never ever do enough public awareness work. That's why this work is ongoing. I think I can fairly say that in terms of the responsible parties, your companies, your government departments and public institutions, there's a fair amount of awareness now due to a number of webinars and public awareness exercises that we've done in the last 12 months. The biggest task right now is to engage at community levels, engage at provincial levels with ordinary citizens, which we do, but we certainly need to be doing a whole lot more of that. So we're always looking out for opportunities where we can partner up with other structures that are embedded in our communities so that we take the message around POPIA, and the work of the Information Regulator to where it's most needed, because that's where most of the challenges in terms of access to information, in terms of protection of personal information, that's where these problems manifest. So we need to be there. We are also going to be conducting a public opinion survey this year to test levels of awareness around the work of the regulator and awareness about PAIA and POPIA. We are hoping that the findings from the public opinion survey will inform some of the programming that we are going to do in terms of creating more public awareness. But certainly, we can never be satisfied with the level of public awareness that has been done. But more can still be done, most certainly.
Fair enough. You know, data is considered one of the most important commodities of our times, and on that basis, the work you do is incredibly important. Mukelani, Dimba, thanks very much indeed for speaking to us. Appreciate your time on the AM report this morning. Mukelani, of course, is with the Information Regulator of South Africa.